so we're going to talk about contracts because that's really important. And until you don't get paid on a contract, you don't really understand how important that is. Anyway, that's me, but we talked about that. Okay, I'm not offering specific legal advice to anyone unless you're my client, in which case please follow my legal advice. Okay, we're going to talk about contracting. I'm going to start with who hired you because believe it or not, it's a problem. And I can't tell you, I must have 3 or 4 cases I can think of right off the top of my head, which one of the issues is who are the contracting parties. So is it residential, is it commercial, is it publicly owned? You need to know that. That's very important. And how many of you use the Central Appraisal District to confirm ownership before you start work? Okay, the Central Appraisal District, there's one for every county in Texas, all 256 or something. And its information is free. Some of them are a little easier to navigate than others. But you should, before you start work, check and make sure that you have contracted with the right party. Those of you who are familiar with the Central Appraisal District, do you know how to tell whether you're looking at business person? Yes, ma'am. Oh, yeah. Whether you're looking at business personal property or whether you're looking at real property. Does anybody know how to do that? Okay, so if you look at the Central Appraisal District, and if I was really clever, I could do that and you could see it, but I don't know how to, whatever. If you look on the Central Appraisal District and there's no legal description, that means that it's not the real property owner. It's either business personal property, which is, you all get a bill every year from, I don't know whoever. And they charge you because you have computers and desks in your office, right? So that's business personal property. But also, if you're Target, you don't own the dirt. You own everything above the dirt. That's business personal property too. There's no legal description. And that's important to know because if you're working for a leasehold, you are going to lien the leasehold, you're not going to lien the property owner, and vice versa. So it's really too easy to check not to check. So I encourage you all to do that moving forward. If it's a homestead, the husband and the wife must sign the contract before the work begins if you want to have the option of filing a lien on the property to get paid. So if you don't care about your lien rights, doesn't matter. If you do, get the husband and the wife to sign. That is true whether or not the spouse is on the title. And it's true whether it's a mom and a son or whoever, right? It doesn't have to be a husband and a wife. Yes?
What's the easiest way to be able to access that information so that they know whether or not it is a homestead?
Sure, Central Appraisal District. So if the property address is the mailing address, then it's almost certainly a homestead. If the property address and the mailing address are different, it's almost certainly a rental. Or it's one that's being built as a custom home. And you're not going to be doing re-roofs on something that's being built for a custom home. So that's a good question. Thank you. So that's how you can really tell. You don't have to designate the property as a homestead with the Central Appraisal District in order for it to be a homestead. If you live there or you have an intention to live there for an indeterminate time, it is a homestead. So whether or not they're on the title, this is Texas is a community property state, and whether or not someone's on title, they have a community property interest. And so I would, if I were a salesperson, I'd say, hey, are you married? Or do you have, whatever, who else lives here with you? You can usually tell if there's a male or a female living in the house just by, looking around and having a little conversation. So they don't have to sign at the same time, and they can sign by DocuSign, but they must sign the contract. All right, if it's commercial property, it's almost certainly not an individual. Almost certainly Bob Smith does not own that giant building. So because salespeople are very relational, if you're speaking to Bob Smith and Bob Smith is the guy that you're negotiating with and you're signing the contract, you're going to, there's a temptation to put Bob Smith as the owner. Bob's not the owner. That's what the Central Appraisal District is for, and it's really, really, really easy to get the wrong company name. I have a client, not in this area, who had 2 signed contracts. I could not figure out who the owner was. I mean, it was just ridiculous. There was a building owner, there was a building name, there was a property owner name. The addresses didn't match. The person's name on the contract was not any of those. It was very difficult to get a lien filed. And we could have avoided all of that by doing a little due diligence at the beginning when the contract was created. Or really before, I mean, if the salesperson's going to sign whatever they're going to sign. Hopefully they're bringing it to the office. The office is confirming the information and making any corrections that are needed prior to the start of work. So the signature block should have, president, CEO, CFO, managing member, some sort of designation so that there's a representation of an authority to sign the contract. Property managers are agents. They're not general contractors. They're not separate contracting entities typically. But ask, because some property managers do all the contracting for their clients. And y'all can have, I'll send you this electronically. You don't have to take pictures if you don't want to. So property managers are typically not the contracting parties, but sometimes they are. And how do you know? Because you're going to ask. HOAs, how many of you ever do work on HOAs? So, the HOA president signs something and then he's or she is gone, and there's a new HOA president and their cousin's a roofing contractor, and suddenly the previous person didn't have the authority to sign the contract and you're out, right? So happens all the time. You can avoid that by having the board issue a resolution that's either in their minutes or signed authorizing the contract. So these little extra steps, they don't take much time, really don't even take that much thought, but it'll help you make sure that you have an enforceable contract. Okay, so here are kind of the big ticket items of what needs to be in your contract, and we're going to run through all of these here quickly. Okay, so if you want to file a lien on a homestead, you must have your address on the contract. And I see a lot of contracts that don't have addresses on them, and there may be several reasons for that. But, you should have your address on your contract. And if you have multiple addresses, that's fine. Put them all on there. If you are working from your home, that's great. Maybe you want to get yourself a virtual suite, office suite, executive suite. My husband's been in an executive suite for 25 years. And it works great for him, and his mail goes there, and I don't have to screw with it. But I don't believe a UPS mailbox is going to work. So I think you really need a physical address to comply. And that's only for liens. It's only for homestead liens. Okay, contract must-haves. And by the way, other than for homestead liens, you don't have to have a written contract. So you can actually go and do things on a handshake, but you'll almost certainly be coming to see me later because that handshake means different things to different people. I've litigated, I litigated $1 million roof on a handshake, and it was painful. It was really painful. So you don't have to have a signed contract. You can have a verbal agreement. You can form a contract with a proposal and a text message accepting the proposal. So there's a lot of different ways you can form a contract. This is the best way. But you can still have a contract that's enforceable without even a single piece of paper. So all contracts for storm restoration contractors must have the deductible language in them. Hopefully we all know that. Minimum 12-point bold font. It can go anywhere in the contract, but it must be in the contract for you to be compliant with this law. Here is the language. I recommend you just use the language that the legislature has approved. Just stick it in there. I am not a trusting soul anymore after being an attorney for a while, so I created this little box in the bottom left corner, and I like for my clients to have the insured fill that out because the contractor is responsible for collecting the deductible. It's just this is one of many one-way laws. And if your insured represents to you that there's no insurance that's involved, then let them make that representation to you so you don't get in trouble for not collecting the deductible. And then I have them fill out the amount of the deductible, because if the insured tells you it's $2,000 and it's really $10,000, you have not complied, right? But it's not your fault because you were there was a misrepresentation, you were misled. So anyway, that's it. The checkbox is not required statutorily. It's just something to consider. Okay, residential contract. Yes, sir.
The same applies like if the homeowner, it is an insurance job. They're like, oh, I'm gonna pay out of pocket for the estimate. So basically the same thing applies. Like you just make them sign that it's not an insurance job, even though it is.
So the question is, if they tell you they just want a retail contract, do you still have to collect the deductible? So technically, yes, you would still collect the deductible. Most folks don't, and most carriers don't make an issue of that. But really, as a best practice, if you really believe that, just have the retail contract divided into deductible and balance and be done. So if it's a $17,000 roof and it's a $2,000 deductible, you have a $2,000 deductible payment and you have a $15,000 balance. So, whether someone's going to make a thing of that, I've had insurance attorneys tell me they don't care about that. But the fact is, you don't really know until it's time to get paid at the end whether there's going to be a problem. And rather than have a problem, just comply with the law. So that's a good question, though. Okay, so residential contracts, because Texas values home ownership, there are, yes, sir?
But that's only in the case if you're gonna submit paperwork to insurance, right? So if you're filing for any type of depreciation or or they're gonna take that paperwork and pass it on, right?
Right.
So insurance and your name gets involved in that claim process, right?
Right,
And that's
so-
where you need to be careful, but if you're just doing like a cash bid deal, like, hey, this is our price only, I'm not sending nothing to the insurance, I'm not getting involved, that's your business, right?
So that's true unless the homeowner says, oh, you know what, I can't pay you the balance of my cash bid until I get the money from my insurance carrier. So, sometimes they just want to have it both ways. So yes, it's true, if they're just going to write you a check, who cares, get the check, move on. But I have seen instances where it was supposed to be a cash bid and it ended up turning into a hybrid, and in that case you just want some extra protection. So, but that's a good question. So because Texas values home ownership, they have additional things in place to protect home ownership, and these are a couple of them. So your contract has to have the 3-day right to cancel. This is the most misunderstood thing of anything I've ever run across when it comes to a contract. So it's for protecting consumers of door-to-door sales. It applies to in-person solicitation by the salesperson that is initiated outside the contractor's office. So if you're at Costco, if you're at a ball game, if you're, getting your oil changed, right? If you're door-to-door, it doesn't matter. If you are outside of your office and you are soliciting an in-person sale, this applies, period. So that means it does not apply if they're responding to a Facebook ad. It does not apply to referrals. It does not apply to anything that is not an in-person solicitation initiated by the contractor. The question is, can you prove, if they want to cancel the contract, that it was not an in-person solicitation outside, right? So most of my clients just keep this in the contract because it's simpler than trying to differentiate and train folks about when and when not to use a contract with that in it. If you never do door knocking, if you never do solicitations, if you never have conversations with anybody about whether they might need a new roof, then you can leave this out. If you do, I recommend you have language in your contract that says, I, homeowner, acknowledge that this was not an in-person solicitation by the contractor, and have them initial it, right? Because the fact is, if you don't follow this law correctly, the contract can be canceled at any time. including after the work is done, which is ridiculous, but it's true. So, and that's when I talk about severe penalties, that's really what I'm talking about. It does not apply to businesses or rent houses. So a rent house is considered commercial for the purposes of this law and a lot of other laws. It applies to someone who is living in their home and you come and knock on their door or you interrupt them in their day and you get them all excited about your services and then later they're sorry and they wish they could take it back. So that's what this law is for. The consumer has the right to cancel for any reason, no reason. The right to cancel cannot be waived. They have 3 business days to send the notice of cancellation, and as long as it's postmarked, then it's an effective notice. And even though the law says, send it by mail, there's lots of kind of general law in Texas that says any kind of actual notice works for notice. And so if you got an email saying, I'm canceling, and you said, well, I'm not going to allow that cancellation because you didn't send it to me in the mail, I don't think that's going to work. So, and honestly, do you want somebody who doesn't want you, right? That's the thing. What's a business day? Probably not Saturday or Sunday. So, Monday through Friday kind of a deal. Okay, so there's a 3-step process. The first step is immediately adjacent to the signature block, you have to have this language in your contract. So not on the back page, not anywhere other than immediately adjacent to, which is above, below, or next to the signature block. Minimum 10-point bold font, any font you like, but this is the language that you want to use. So this is step 1, is you have to have the right language in your contract and you have to have it in the right spot in your contract. You have to provide 2 paper copies. So you can have the contract signed by DocuSign, but at the time of signature, you have to give the homeowner 2 paper copies of the right to cancel. That's just what the law says. So my contracts have 3 copies, and the 3rd one is an acknowledgement of receipt of the cancellation form, because a homeowner is going to be hard-pressed to say they didn't get that notice if they signed an acknowledgement that they got the notice. So you have to put it in the contract. You have to give them the 2 paper copies of cancellation notice, and you have to tell them of the right to cancel. So you have to do it at the time that the contract is signed. You have to tell them in the language of the contract. So if you're speaking English, great. If you're speaking another language, it all has to be in that language. The notice of cancellation, the verbal notice, and the language, that you have the right to cancel language. This is the notice of cancellation form, 10-point bold font. Believe it or not, the notice of cancellation has to be a 10-point bold font. I don't know. Somebody just really likes 10-point bold font, I think. Oh my God. Anyway. Okay. So that's the first thing, is a 3-day right to cancel. The second is, this is Chapter 27 of the Texas Property Code. This is a mandatory notice that must be in all residential contracts. And this is actually friendly to contractors. So this is the notice that says, look, if you have a beef, you need to come and tell me about it and give me a chance to fix it. If you don't, then I don't have to pay when you have somebody else fix it and you try to give me the bill. So this is a good notice to have. It can go anywhere in the contract. Resist the urge to rewrite this. Just put it in there like it is. Minimum 10-point bold font. And actually, failure to include the warning subjects you to a $500 civil penalty. And I've had situations where I have filed suit on behalf of my client to get them paid, and what I got back was a counterclaim for $500 for failure to have the Chapter 27 warning in it. So just, put it in. Okay, Chapter 41 of the Texas Property Code. This is an unfriendly notice, but it is required to be in the contract. And I had a client not very long ago who said, hey, the homeowner wants to strike this, can I do that? And I said, no. Tell them it's statutorily required, it's nothing personal. It's to let them know if they don't pay their bill, they run the risk of losing their property. So this is statutorily required. Failure to have this in the contract can lead to treble damages. whatever those damages might be for failure to warn. I guess if they lose their house, that would be a damage anyway. So, but failure to have this language in the contract does not invalidate a lien. It just subjects you to a fine. And you can, if you want to, in parentheses, put statutorily required, chapter, 41, Texas Property Code. It makes it seem a little less unfriendly. Okay, optional stuff. Okay, as far as I'm concerned, this is not optional. Everybody who is a storm restoration contractor of any kind, any mitigation, should have this UPPA, unlicensed practice of public adjusting. Y'all are familiar with public adjusting law? Yeah, okay. So a huge percentage of the time when I file suit against an insured for non-payment, I get a UPPA violation counterclaim. Happens all the time. And the penalties for UPPA, and I've got a handout if anybody wants to know more about it, they're very severe, and you want to avoid them if you absolutely can. So this acknowledgement will help with unintended representations that might be construed as an offer to publicly adjust. So that's the purpose of this. I like it at minimum 10-point bold font because we all love minimum 10-point bold font. So I have these in all of my contracts, and I recommend, you can reword this if you want to. This is just my standard language. But I really do strongly recommend you have these in all your contracts. Void or voidable. Most contracts I see are contingency contracts, and they say I'm going to do the work approved by insurance for the RCV value of the claim, plus extra stuff you want, blah, blah, blah. But most of them say the contract is void if the insurance carrier doesn't approve the claim. But how many times have we seen an initial denial followed by an approval? So what we don't want is we don't want the insured to say, yeah, I'm out because I got a denial and now I can go use my cousin. So what I prefer is that the contract is voidable either by the contractor, if the insurance company doesn't approve a legitimate scope or an acceptable scope, or it's mutually voidable so that the contractor doesn't end up getting one of those, yeah, I'm out, I'm voiding this contract because, my insurance carrier, didn't whatever. So I prefer voidable to void. And I like the proposal may be withdrawn if not accepted within, some number of days, and really for a couple of reasons. One is to create a little sense of urgency, in the sales process. And the other is because sometimes if you wait too long, oftentimes if you wait too long, the price goes up, and then you're stuck with a price you may not want to work under. And so that's just optional, but I put that in there. And then the bottom language, after the right to cancel is passed, any attempt to terminate, that's kind of threatening. Not everybody loves it. I love it because I don't want people to cancel their contracts. I want them to abide by their contracts. Okay, termination fees. There's a lot of misconception about termination fees. Some people say they're only enforceable if they're a set amount. Others say they're not enforceable at all. They are absolutely recoverable if they're properly described and they're properly contoured in the contract. So a termination fee really is a substitute for lost profit. So as long as you're not seeking more than you would reasonably expect to recover as lost profit, then your termination fee is enforceable. So don't call it liquidated damages. That's a whole kind of a different thing in the law, and you just don't call it that. Just call it a termination fee. You are entitled to lost profit whether or not you have a termination fee in your contract. And if your termination fee is 15%, but your lost profit is 35%, you're entitled to your 35% if you are the non-breaching party. So just because you have something in your contract that says if you decide to terminate, you're going to pay me 20%, that doesn't mean that you've maximized how much you're able to recover. It's just really, it's for the purpose of encouraging people not to cancel their contracts. And if you want to say that you recover your reasonable out-of-pocket fees, so, you would have that in there. So it doesn't, a termination fee is not invalidated because it's expressed as a percentage. There's misinformation out there that that's the case, and that's just simply not the case. Most of my clients are anywhere from 15 to 35%, which I think is pretty typical. And so net profit is, total contract less what it would have cost you to do the job had the job been completed. And that is, for the most part, normally between 20 and 35%. So, material shortages, I don't know if this is still a thing. I have some clients who tell me it's a thing. I have other clients who tell me it's not a thing. If you have a concern about material shortages and delays in the work starting, this might be something you want to consider. And then, the optional notice of, if it ends up costing me more, I need your help to go get me paid from insurance. So, subject to management approval. Does anyone in here use subject to management approval? So, there's a good and a bad to subject to management approval. When you have that in your contract, it means that your salesperson can't go out and obligate the company to some crazy something, right? So, they decide to go, sell something that doesn't have any profit in it or is outside your wheelhouse or whatever the case may be. Then management can say, no, thank you, we're not going to accept that contract, and you just, you let the other person know. The bad thing is that you don't have a contract until management has approved it. So you are extending the time period during which you don't really have an enforceable contract. So what you want to do if you want to have it be subject to management approval, you just need that process to be as quick as you can, make it, and then you need to let the other contracting party, the insured, know when the contract has been signed. So, yes, we've accepted your project, we're contract, we look forward to whatever, we're ordering whatever. And language, when I have these kinds of provisions in contracts, I will also include a provision that says purchasing materials is acceptance of the contract, so that no matter what, at the point where you've really committed funds to the project, you have accepted the contract and then it's binding. Because contracts are offer, acceptance of material terms, right? It doesn't actually require performance. Performance is nice, but offer and acceptance is really all that it takes. But you have to have acceptance, and you don't have that with subject to management approval. And then what performance standard controls your work? So it's not a roofing contract, but my dad was a general contractor most of his life. And then when he shut his business down, he became a expert in construction disputes. And he sent me his contract to look at, and he said, I'm offering the highest standard of, and I'm like, Dad, what are you doing? Don't promise, well, anyway, I think he was kind of offended because I told him, don't promise something that is that hard to hit. But the same is true here, right? So what standard are you promising that you're going to do your work under? A good and workmanlike is kind of the standard, right? The typical standard, right? And that's really what should be in your contract. Good and workmanlike means of a standard that is performed by kind of your average, fellow contractor. So it's kind of like a C+, maybe like a B-, right? It's not A-level work. It's not, I don't know how many of you guys have painting done, but there's 4 or 5 different levels of painting. And it's not the level 4 painting where you have the flat surface with no texture and the paint has to be perfect or you see every, smear, right? It's not that. So it's good and workmanlike. It's suitable for its intended purpose. It's something that would allow, the homeowner to have all the warranties that are in place. It's, doesn't leak, et cetera, et cetera. So all applicable codes, that's pretty standard. And most applicable codes, from my understanding, include compliance with manufacturer recommendations. So those kind of come hand in hand. So just, if you want a higher standard, just understand that whatever is in your contract, that's what you're promising to do. Scope exclusions are very, very, very important. And I hope you all are really thinking about what kinds of things you have no control over so that you're including those as an exclusion to your contract. And of course, the whole 3 inches from the deck, underside of the deck thing, super important. Nail pops, broken vases, damage to landscaping and driveways. You have no idea whether that driveway was poured correctly. And you don't want to be responsible for cracking it if your delivery truck backs into it. God, is it hot as hell in here? Is it just me? Maybe it's just me because I'm talking so fast. But honestly, I'm hardly ever warm. So anyway, so all of the things that you want to avoid, make sure they're in your contract. Because if they're not in your contract, then you're going to have a big fight over whether or not it's something you should legitimately be responsible for, including cosmetic issues, if you're matching colors, whatever the case may be, right? You like my cartoon? It's pretty cool. Yes, sir.
How do we, stay outside of the conversation, but reassure a homeowner like, hey, free online gets it wasn't supposed to be there. I'm happy to provide you the documentation of that, and because we see insurance will often pay for that repair and whatnot. But I don't want to promise it, and I want to, because some people get into the weeds of those exclusions and they start freaking out.
Right. So that's not really a UPPA thing. It's really if you're excluding it.
But if I'm saying I'm happy to help you, homeowner. We had someone that their line went through this, we were redoing the siding too, and they run the line set behind the zip board, and we nailed into it. Didn't know for 3 months when they turned the air conditioner off the first time.
Right.
So then we documented all that for them. They paid out of pocket to get it fixed, but I helped them essentially submit that to insurance.
Right.
And they got it added to the claim.
Right.
And so
So
I'm happy to help people with that, but I
sure.
obviously am doing that as the contractor, not a.
Yeah, so the short answer is, as long as you're sticking to price, scope, and necessity of work, you're fine. When it's not good to promise a homeowner that insurance is going to pay for something. It's not necessarily a UPPA violation, it's just a really bad idea. Normally insurance would pay for this. I can't promise you they will. Here is an estimate for the repair work. I'm happy to submit that to insurance if you'd like me to. It's when you start telling the insurance company something should be covered or paid, that's when you get in trouble. Or when you start horse trading, they say, well, could you do it for $500 less? Well, now you're negotiating, right? So just don't do that. But anytime you're identifying damage, talking about pricing, it's okay to talk about whether something is related to storm damage. Right? All of that stuff's fine. As long as you stay talking about things that are within the purview of a contractor, you're typically fine. Okay, so this provision right here is the result of a client of mine getting crossways with an owner who thought that my client had broken one of the rafters and that's why the roof was sagging. So my font gets smaller and smaller every year because I got to put more and more stuff in the contract because my clients have run across something that I got to address so that the next person doesn't get tagged with it. So I like the picture of the lion. I thought that was cool. But anyway, so this is something to consider. It really does happen a lot because nobody looks at their roof until they have a new roof. And they're like, oh my God, that thing is, blah, 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 right? So it's good to have something like this in there. And then it's good to talk about, you're likely to see things and you think it's the first time, but really it's just because, construction's not perfect. Opportunity to cure is big. So you want an opportunity to cure any perceived deficiency or to demonstrate that it's not a perceived deficiency. And here is, some criteria that you can consider. that you might want in your contract. Actually, all this stuff is in my contract. Time limits are good, right? Because you want to avoid open-ended, and you want to avoid this has been leaking for 2 years, but I'm just now telling you, and so now you have to fix the leak, and you have to fix, all of the damage that's resultant from the leak. So time limits are probably one of the most important aspects of an opportunity to cure that you want to make sure are in your contract. So owner changes. Most contracts say that all change orders must be in writing, right? That's kind of typical. So there are customers who think that they can get you to do things verbally and then they don't have to pay for them because there's no written change order. And that's actually not the case, because you can orally modify a written contract. So even if your contract says that all changes must be in writing, if you perform a change, even though it's not in writing, you're still entitled to be paid for it. It is better to have some documentation about what the agreement was. So, they want to upgrade to whatever, or they want you to, paint the outside of their house, or whatever the case may be, right? So, text messages are legally enforceable communications. So, if nothing else, you asked me to do this XYZ thing. We have it on the schedule. We will let you know how much that's going to be, before we start, or we'll, send you the bill or whatever. If they don't text back and say, no, I never wanted that, then there's a presumption of agreement. It's better to say, you've asked us to do XYZ. It's going to be, $14 a square foot or whatever. Please text back and confirm the color selection and approval for the work. Right? It's better to have that extra level of communication, but there is a presumption of agreement if they don't text you back and say, no, you're out of your mind, I never said that. So you can email and somebody can text you back. You can send them a contract and they can text you back and say go. You can give them a written contract and they can email you back and say go. So as long as they don't email you back and say, oh, no, that isn't what I wanted this other kind of a shingle, or, can you do it for $5,000 less, right? So unless they're making a counter offer, any communication that is an acceptance forms a contract. So then when it comes to owner changes, I like to have in there that you have the right to perform work on a verbal. You do anyway, but it's one more thing that lets them know that if they ask you to do something, they're going to get a bill for it. And then if you don't agree ahead of time on the cost of the work, then it's going to be the reasonable value of the work. It's better to agree ahead of time, because reasonable value means that somebody's going to decide what the reasonable value is. And I have a lawsuit right now. Actually, we're going to go to trial on Tuesday. And one of the issues is our client says the reasonable value is 74, and the other side says the reasonable value is 26. So 3 years later, and I can't tell you how expensive the lawsuit has been, because the opposing party and opposing counsel is a pain in the whatever. Anyway, so it's just better if you can, the more concrete you can be, the better it is, but really it takes very little to form something that's binding, much less than people think. The right to supplement, hopefully your sales team is explaining what supplements are, and they're explaining how common they are. I do have a handful of clients who very seldom supplement, and I don't understand that, because I just don't get it. Because insurance companies just chronically undervalue claims. But if you want the right to supplement, it's best to get it in the contract. And that especially helps when it comes time to collecting payment, because I'm sure we've all heard the old, oh, I thought that was my check, because, right? So to avoid that, this kind of thing is best.
Okay.
Yes, sir.
Okay, so
Okay.
negotiating part. So this literally is saying we can negotiate.
Nope.
But
Does not say you can negotiate.
communicating is
No,
negotiating?
communicating is, no, it's not.
So do you have to independently?
Okay, Stephen, I tell you, I'm gonna paint your house, or I'm gonna paint his house. And I'm gonna do it and you're gonna pay for it, because you guys are buddies, right? So, I'm gonna paint his house, nice, right? Okay, so I'm gonna paint his house, and I think the value of that is $40,000. And I give that to you, and I say, here's my estimate, right? I'm not negotiating. If you come back and say, well, I'm only going to approve 36,
So you're saying the fault is negotiating with the customer?
nope. Negotiating with the adjuster is forbidden. Negotiating with the customer, you come back and say, I'm only going to authorize 36. So I'm like, well, that kind of sucks. So then I may go back and I may say, you know what? They're only going to pay 36, so will you pay an extra 2,000? And then I'll take 2,000 off, and he'll take 2,000. He'll pay me 2,000. I'm negotiating with him. I'm not negotiating with you. I can say yes or no to you. You can say yes or no to me. That's not a negotiation. That's just communication. But if you say I'll only pay 36, and I'm like, well, would you pay 38? Now I'm negotiating the claim. See the difference? Does everyone see the difference?
So is it safer to just have a third party do that portion?
Well, it's just safer not to get over your skis.
Right,
So,
But you can still discuss the scope of
Yeah,
where you need it to be.
right.
But the homeowner can go back.
Well, you can't negotiate scope either. You can't negotiate any aspect of the claim with the adjuster.
But we can ask questions, right?
You can ask questions. You can say, look, this is why I have 15% waste, right? And, they can say, well, our criteria, whatever, right? So unless you say, well, let's agree on 10% waste, that's a negotiation. That you can't do, right? I mean, if the letter of the law, I know it happens all the time.
Years down a course so I'm communicating with insurance.
So we're just gonna talk about UPPA,
Down the
yeah.
road of sucking me into a negotiation. Right?
So,
Which is what happens.
UPPA is a one-way law. So the adjuster is never going to be at fault for tricking you into negotiating. Right? You're the only one that's going to be in trouble for negotiating. The adjuster's never going to be. So whether the homeowner tricks you into it, whether the adjuster tricks you into it, you're the only guy that's going to get in trouble. But we're not going to talk about.
Awesome.
Yes. So, okay.
So, but the 2,000 splitting it that you're talking about, the homeowner can go back to the insurance company.
Yeah, the homeowner can go back and say, are you crazy? There's no way that can be done for $36,000. I need you to approve 40, or I need you to approve 38, and the insured or the claimant can negotiate that all day long. That's not a violation. A public adjuster can do that. An attorney can do it. The contractor cannot. Absolutely.
I put them up, like, hey, yeah.
Yeah, okay.
I understand. I just wanted to,
That's all right. It's a good
understand
question.
the gray area in my mind.
Karen, real quick, along those lines, sometimes based on the insurance policies, they say a particular scope. They can't put the scope in using whatever that exact line item is. Like, hey, I can't apply O&P, but I can give you X many hours in supervision. If they're offering that and you say that would be fine.
What does that sound like to you?
Negotiation.
Okay, just checking. All right, just checking. No, it happens all the time. Here's the thing. They say, here's what I can do. If you say yes, that's not really a negotiation. That's just a capitulation. Right? But if you come back and say, okay, well, I can do that, but I'm going to need another 25 hours. Right? So you see the difference? So the law sucks, and it's full of pitfalls and all that stuff. But and a lot of times it doesn't matter until it matters, right? And then it really matters a lot. So I'll let you know how it goes on Tuesday with that.
Isn't all that just way down the road? It's all recorded. right? Like you have to keep in mind.
I
when you
assume-
call in, those are all recorded.
I assume all calls are recorded,
So that's another
right?
thing that I always.
Yeah, I assume all calls are recorded. You should assume if you're on a roof with somebody that it's being recorded. Yes, ma'am.
This is a little bit down the ways. Does the negotiation part count as far as like quantities and stuff as well? Like
If you can negotiate anything, any negotiation over any aspect of the claim.
a discrepancy, that needs to go through the homeowner back to the insurance.
Right. You can either say, no, I'm going to, my bill is going to include 25 feet, and you can pay whatever of that you want to. Homeowner, I need to let you know they're only paying 20 feet of my 25 feet, so you're going to get a bill for the difference, right? And then you document that because the homeowner needs to say yes, otherwise you're only going to get paid the 20 feet because your contract says you're going to get paid what insurance, right? So, yeah. But yeah, it's not just money that you can't negotiate. It's really all of it. So, okay. Authorization to contact adjuster should be in your contract. Really, the purpose of this is so the adjuster will talk to you. But be careful about what your authorization allows you to do. Price, scope, payment. Right? That really should be what you're limiting yourself to. Hopefully nobody has best interest of the homeowner in their contract anymore after all these years. I still see it every once in a while. Thanks for turning the air down, by the way. That's nice. Okay, overhead and profit, I really hate even bringing this up because it just is a really contentious, frustrating issue. Here's what I really want to make sure you guys understand so you can think about how you want to handle it in your contract. If you say, I'm going to do the scope insurance approves for the RCV value of the claim, and the insurance company does not approve overhead and profit, you're not getting it, right? So you would have to have a separate provision in your contract that says, but you're going to pay me overhead and profit anyway. Otherwise, it's just not going to be available unless the carrier gratuitously offers it to you. So, payment terms. So I like to say I like payment early and often. I like the property owner to understand that they're going to actually pay for my services if I'm the contractor. So I want them to pay the deductible pretty quick after they sign the contract, so they understand that this is actually an you pay and I do kind of a situation. And then I like a material draw the day before materials get dropped, because almost always, well, by then you've lost a lot of your leverage, right? So, if you show up the day that the work starts and you want your materials draw and, they're not home, so now you've done, either all of the work if it's a one-day contract, or you've done half of the work and you've never received a dime or whatever. That's not great. And so I like that. Now I have lots of clients who say, until the work is done and accepted, you don't pay me a penny. That's really risky. It is less risky if it's a referral, but it's really risky, and I'm not a fan. But if that's your business model and it's working for you, that's a business decision. I just prefer, incremental payments. And if it's a long job, or they haven't quite decided, what pieces and parts they want for all the various ancillary things, you should have the right to charge by trade, charge by month. And it should always be, final payment is based on substantial completion, not final completion, not final acceptance by the owner. So substantial completion means the work is fit for its intended purpose. That's what substantial completion means. And that should be the standard, and because I don't know, maybe you've never had an unreasonable property owner who refuses to accept the work and just keeps coming up with reasons not to pay, but it does happen. And so if you tie your payment to substantial versus final completion, then you can eliminate some of those arguments, because there's punch work and there's warranty work. And then interest for late payments, which we'll talk about, which I may have to I'm not sure where this is in the presentation. Let's talk about interest, just to make sure it gets covered. So 6% interest is the baseline standard, the statutorily authorized for contracts that don't have a different percentage of interest recited in the contract. So the minimum you get is 6%. If you want more than 6%, it has to say so in the contract. The maximum you can get is 18%, which is 1.5% per month. You cannot charge 2% late penalty per month for non-payment. You cannot charge 5%. That's usury. That opens you up to all kinds of really bad stuff that you just don't want to deal with. You also cannot charge interest on interest. So, let's say, I don't know, I can't do math in my head. But let's say whatever you're charging, the first month's interest is $150. Every month's interest after that should be $150. It's not $150 and then $153 and then $157, right? If you're doing that, then you are charging interest on interest, and you can't do that because that actually bumps your interest rate up over 18%. So don't do it, please. And then the other question is, when does interest start accruing? So by statute, interest starts accruing 30 days after the payment was due. So if your invoice says, and I hope you're all sending invoices when you're doing your work and you're finished, right? I have some clients who still use certificate of completion because then they don't have to disclose to the carrier what they did and what they charged. I don't know, that doesn't really seem to work very well anymore, but your invoice, if it says due in 30 days, that means your interest doesn't start for 60 days, right? Because it's 30 plus 30. So if your invoice says due upon receipt or due in 10 days or whatever the case may be, just understand that whatever that due date is, that's what's going to trigger interest that starts to accrue, unless your contract says interest starts to accrue 3 days after you get the bill. Then you're entitled to interest at that point. Warranties are very important. Your warranty terms need to be in your contract and not just in your warranty, because if you save all your warranty terms for when you issue the warranty, it's too late. Those terms are not enforceable against the contracting party because they were not agreed at the time the contract was entered into. So they need to be in the contract, at least the basics of them. How long is your labor warranty? What does it cover? Is it transferable? Personally, I'm not a fan of transferable warranties, because if I qualify Brett to be my customer and then Brett sells his house, and this guy, he's a nice guy, but his wife is crazy, right? And no matter, right? I'm sure your wife's not crazy. I'm sure she's very nice, right? But now you have a warranty with a crazy woman, right? So I'm not a fan. A lot of my clients have transferable warranties. It certainly is a selling point. Just understand what you're signing up for, if that's the case. So, and it should always run from substantial completion and not final completion, because as we talked about, final completion can be very hard to agree to, and it should not be extended. Additional work should not extend your warranty. So. Your warranty should always be conditioned on payment in full. The last thing you want to do is you want to have to give somebody a warranty when they haven't even, paid you the first dollar that they owe you. That's not great. So it should be conditioned on payment. Now, materials warranties, maybe they're a little bit different. Although you can by contract withhold a material warranty. Not all material suppliers will agree to that. And then what voids your warranty, right? You need to be thinking about that. Misuse, owner neglect, new storm, 50-mile-an-hour wind, anyone else, monkeying around with your work, all that should void your warranty. Because the last thing you want to do is have somebody up there screwing something up and now you have to go fix it for free. Advertising. So generally speaking, you cannot take a picture of something that doesn't belong to you. So if you want to take a picture of something you did and you want to, especially, well, even if you just want to take a picture, but especially if you want to post it, you need to get permission to do that. And so this is the language we have in our contract for that purpose. Do not include addresses. Do not include homeowner names. That is a whole nother kind of problem that you're opening yourself up for, unless now somebody can give you permission to be a reference. Some I've seen contract packages and they have, here's 3 or 4 references you can call to confirm that our work is good. That's fine. You need to get permission for that. But you don't ever want to publicly post someone's home address or name on the internet. I think it's actually a criminal violation to do that without permission. Yes.
Splitting hairs, that's kind of what you do, right? So
It's what I do. I split hairs. You bet.
when does it legally become their property? When it goes on their house or when they pay the bill?
Yeah. So when does something legally become their property? Well, that depends on what the contract says, right? But it's hard to take a roof off. So at the point where it's installed, you're going to be hard pressed to say it's yours still. Now you can take, a whirligig off or something and then plug the hole. But yeah. My contracts always say you don't own it until you pay for it. But practically speaking, how do you take shingles back or how do you take the underlayment back, right? It's kind of hard to do. So yeah. I've had clients in the dead of night go take stuff, and I'm just like, okay, well, just don't tell me till after you do it, because I don't want to. I don't want to be sitting in the dock with you. Yeah, people are crazy. All right. Other conditions: do you charge a restocking fee? You should if you're going to incur a restocking fee. Who gets to keep unused materials? Certainly, that's something we've thought about. The homeowner thinks that all that stuff is theirs and they get to keep it, and it's not. So, and then, how do you handle delays for weather, et cetera, et cetera? HOA approval, that should be on the insured, not you. Always. It just, oh my God. HOAs, I hate them. Okay, injury to the uninvited. So your contract should very clearly say that the insured is indemnifying you for damage to people or property that are inside of the work area without your permission. So I have a client not too long ago, and they called and said that somebody had dropped a bundle of shingles on the head of the homeowner as they were coming out their front door. So fortunately, that person was not injured. It was a little testy conversation going on at that point, but you can't really tell a homeowner not to come out their front door, except kind of you have to, like, don't come out your front door because this is the side of the house we're working on, so use your garage door right anyway. So it ended up not being a thing, fortunately. But for sure, if little Johnny wanders into the work area and stumbles over something and gets hurt, you don't want to be the one to get that bill. So. And then you want the owner to agree to aid in collection of payment, because at the end of the day, it's their claim. They're the ones who owe you the money, and they need to help make sure that you get paid. So arbitration or litigation. I used to hate arbitration, but practically speaking, it is the better option almost always, especially if you are a contractor who's in a dispute with a homeowner. You do not want to be in court sitting in front of a jury and having the wife crying about her disappointment and her angst and her sleepless nights and the kids can't concentrate at school, right? You don't want that. It's not a fair fight when you're in a courtroom. You really want to be in front of an arbitrator. Arbitration is a private process where the decision maker, a private individual, normally an attorney, and when we have our arbitrations, we require construction attorneys because they understand, construction. But they are the decision makers. There's no jury. You are paying for your judge, but it's still less expensive because you're not paying for all the foolishness that goes on in a court case. So if you want to be able to arbitrate against a homeowner, it has to be in the contract in a minimum 10-point bold font, because we just love that minimum 10-point bold font thing. So that's required by statute. If it's not a homeowner, if it's a rent house or it's a commercial property, it just needs to be in the contract, because arbitration is a creature of contract. You cannot trigger arbitration other than by agreement if it's not in the contract. So, you know, some of my clients have mediation before arbitration. I don't know. I like mediation. It can be helpful. Early mediation is hardly ever helpful, but anyway. But if you want to be able to arbitrate, and I strongly recommend that you do, it needs to be in your contract. The other thing is, the downside of arbitration is you get what you get, and that's it, and there's no do-overs. So if you get a bad decision, then you got a bad decision, and they're almost impossible to overturn. So, but if it's a pretty clear issue, or it doesn't matter, you're up against a homeowner anyway, you're better off arbitrating. And then attorney's fees in Texas, the non-breaching party in a breach of contract case is entitled to their reasonable and necessary attorney's fees by law. So you don't have to have anything in the contract that says that. I like having it in the contract for several reasons that are kind of technical. For a practical reason, if someone's reading their contract and they see they might have to pay attorney's fees, they might be less inclined not to just pay their bill and move on. So, and it should not start just by filing suit. It should be available for all collection efforts. So, and I'm almost done. Okay, so here's the interest rate thing. You cannot charge interest on interest. Okay, and that's really it as far as contracts go. So, on your table is this handout. It goes on and talks about some other things, because while I was in Austin yesterday, they had 2 other topics they wanted me to cover. So it's here in the handout, and you're welcome to peruse that and do with it as you will. Also on the table is my handout that I prepared for filing liens on homesteads. And you're welcome to take that with you. It has the process in detail. It has the forms. It has everything you need. Let me show you one thing real quick, if you don't mind. This won't take very long. So she says. Okay. So this is page 52 of the little squares of information. I made this for my office because that says commercial or residential at the top. Sorry about that, it's kind of cut off. Oh, at least on that one, okay. So this is what I made for my office. So when someone sends us in a request and they say they want a lien or they want a whatever, right? I made this because it's really complicated and it's hard to know what thing to do for what thing. So let me just walk you through this, and hopefully this will be helpful, especially if you're doing homesteads. Is it a commercial or residential? Right? If it's commercial, go to the commercial worksheet. Is it owner occupied? Yes or no? If it's not owner occupied, then it's not residential for purposes of this law. Go to the commercial worksheet. If it's owner occupied, are you the prime contractor or the subcontractor? And all of us here are the prime or the original or the general contractor. You're contracting directly with the owner. Was the contract signed by the husband and wife before the work started? Yes or no? If no, no lien. If yes, was the work completed by the 15th day of the 3rd month? Sorry, was the lien, are you within the 15th day of the 3rd month, basically 3 months, of the last work? So this is one of those things where don't wait too long, because you're going to lose your lien rights. So it doesn't really matter when insurance pays. Your lien rights run from your work, and not your invoicing, by the way, but from your work. So by the 15th day of the 3rd month, you have to file your lien if you want it to be timely. You don't want to file an untimely lien. That's bad, bad, bad. Okay, if yes, okay to file a lien. If not, can't file a lien. You just have to send a demand. So we send what's called an FDCPA because we're considered third-party debt collectors by law. So we have a special kind of a notice we have to send. We have to give somebody 30 days to dispute the claim. You don't have to. You just send a demand letter, say, pay me now, or suffer the consequences. If you file a lien, you need to send notice of the lien to the property owner within 5 days of filing. If you don't, your lien is void. And then you have a year to file suit. So if you're a visual person like me and you just follow the bouncing ball, this is really the process. The next page is actually for commercial, and you can follow that too. And is it public work? Is it federal work? Is it whatever the case may be. So anyway, just as a little extra bonus, take a look at that, and if you need any questions answered about that, I'm happy to do it. Other than that, I appreciate your time. I'm happy to answer any questions anybody may have. Okay, great. Well, thank you so much. Do you want to, Kristen?